My lady, my lords, I was just about to turn to ground 2A. If I can invite the court first to turn up the actual ground of appeal, which is in the core bundle tab 1 at page 18. And I'll ask the court to read paragraphs 3 to 5, which sets out the scope of ground 2A. Yes. So ground 2A is challenging the judge's rejection of the 2 to 3 month price lag model. And it's doing so on the basis that he was wrong to conclude that there was no evidence of price persistence which would justify the use of such a lag. And the basis on which that is said, it resolves into 2 points. One is a point about inconsistency with his other findings. And in particular, in all submissions, Mr. Raphael emphasized a finding that was said to be made at 137 of the judgment. And the second point is that the finding is unsustainable on the evidence. And Mr. Raphael took you to some parts of the documents in his oral submission. I just note for the time being that ground 2A doesn't on its face challenge the judge's other reasons for rejecting the use of a 2 to 3 month price lag model. If we take up the judgment, which is behind core bundle tab 5, and if I ask the court to turn to page 93, and draw your attention to paragraph 116, which is the place where the judge expresses his point about evidence most clearly. Whilst I accept that price persistence may in principle be a factor that ought to be taken into account when modelling for a particular industry, whether in fact it is an appropriate factor to be included depends critically on the market or industry being considered. The point made by Mr. Parker, and at least impliedly accepted by Dr. van der Laan, is whether it is an appropriate factor to be included is essentially a factual question. It depends on the availability of evidence that proves the price lag that is being modelled for. If there is no such evidence, none was referred to by Dr. van der Laan, then there is no utility and significant mathematical risk in including. Now, I address the first criticism of that finding, which is that it's said to be inconsistent with findings that the judge makes in the next section of his judgment. My lady, my lords, my short answer to that is that when the subsequent sections of the judgment are read in context, there is no inconsistency. So if we start at 118, it's on the same page, the court will see that the judge is turning to a different issue, which is post-infringement effects. And he starts, one fact I have not considered so far concerns the submission by the claimants that Mr. Parker's model leads to an underestimation of the likely overcharge because it cannot safely be assumed that the effects of the cartel's activities cease to have any effects on the defendant's prices after the date adopted by the Commission. Now, in the next sentence, he identifies 2 different reasons why there might be a persistence. So the first is an enduring structural impact of the cartel. That's a structural impact on capacity. And the second is price persistence, meaning that prices will only adjust back towards a competitive level over time as the effects of a non-cartelized market start to assert themselves. So it's quite clear that when he's referring to price persistence there, he's referring to prices returning to a competitive level after the end of a cartel. And in 119, he unpacks those factors. The effect was suggested to be the result of two factors. If and to the extent the effect of the cartel had been to limit capacity, then there was likely to be a time lag. And secondly, a delay in time between the end of the cartel and the return of prices to levels unaffected by cartel activity. The next sections of the judgment go on to address those two separate points. You'll see at 120, the judge starts with considering production and capacity. And paragraph 120 to 132 is dealing with that issue. So is there going to be an effect on, a relevant effect on production and capacity, which means I can't rely on the post-cartel data. And at 132, which is page 98, and just the last part of the paragraph after the quotation, the judge is again making clear that he prefers the evidence of Mr. Parker on this issue, on the issue of the effect on capacity. So that's the first of the two factors knocked down, as it were. The judge has considered that in that section of his judgment. And on 133, he notes that he's going on to consider the second factor. So I have so far considered the reduction in capacity or reduced growth in capacity in the post-cartel period. There is another issue, however. It concerns the more general point made by Dr. van der Laan that in his view, following a cartel, it is very unusual for prices to return to a competitive level immediately, and it is very unlikely that prices in the post-cartel period would not have been affected after a cartel which lasted around 52 months. His view is there was price persistence in the period after the cartel came to an end, because it takes time for the effects of a cartel on prices being changed to unwind. In Dr. van der Laan's view, and he states his view. Now this, just to be clear, when the judge in the later sections of his judgment refers to the inherent probability he's referring to is the general point made by Dr. van der Laan there. But one would expect it would take time for the effect of the cartel to unwind. We'll see that when we come on to look through the detail of the judge's reasoning. So that's the introduction.
And the judge's characterisation of Dr. van der Laan's evidence in paragraph 133 on this point is not that there was price persistence in the period after the cartel came to an end, because there always is price persistence as a matter of economic theory and all the rest of it, but because of the specific point that it takes time for the effects of a cartel to unwind.
Exactly.
And that, you say, is the point which is carried through the rest of this section and is the finding at 137.
Indeed, my lord. Indeed.
Can I just pick up, not least because it's maybe on the transcript. At 133, you read us the sentence. You said his view is that there was price persistence in the period after the cartel came to an end because it takes time for the effects of a cartel on prices being charged to unwind. Now, I think you actually said on prices being changed to unwind.
I was wrong. The judge is right there.
And indeed, that, to pick up my lord's point, that emphasises it's talking about the prices being charged by
the
cartelists. So you say that this is what he's dealing with. It's that cartelists take time to mend their ways, or become fully competitive, whereas price persistence can result from other factors. Is that the issue?
So the basic intuition here is that where you have a cartel, the hypothesis you're dealing with is that cartelists are exchanging price information they're coordinating on prices. Following the end of the cartel, as a matter of intuition, common sense, inherent probability, you might expect that there will be a period of time before prices normalize to the competitive level. So for the effects of the cartel to diminish, they're not going to switch off immediately overnight on the date that the Commission has found the cartel to end. The question of price persistence, and when you're modeling in a regression, is dealing with a different issue. Because when you're constructing the model and using price lags as an explanatory variable, what you're trying to do is to predict how prices, predict the factors that would have set prices in the counterfactual, so in the absence of the cartel. And so if you're going to include a price lag for the counterfactual modeling, you need separate reasoning to justify why that would be appropriate. The judge's reasoning in this section of the judgment is just dealing with the question of post-infringement effect. And he can understand why you'd expect there to be, well, there may be some persistence after the end of the cartel in the prices that the cartel is charging, because there's been a period of coordination in prices. And there may be a basis to assume, indeed, a good basis to assume that prices are being maintained at a level over a period of time. So there are reasons why you can't infer from one to the other.
So, if I've got this right, you say that the lag that was being talked about is that people generally may not change their prices instantaneously to respond to market factors, such as raw material prices changing or something like that. So it's extraneous factors which wouldn't necessarily, depending on the industry, cause people to change their price, the prices they charge for their products immediately. On the other hand, you're saying that this price persistence that's been talked about here is the effects of the unlawful cartel behaviour suddenly being switched off, and people will take time just to readjust the levels to become fully competitive. Old habits die hard, or what is it?
They're in possession of information about prices. When the cartel comes to an end, there may be a period of time for prices to return to what would be expected to be a competitive level. So a level which removes all of the effect of the price coordination that will have taken place during the cartel. So you've had a period of time where people are sharing information, and you may have, there may be good reasons why you think that just because the Commission has decided on date X as the end of the cartel, that doesn't necessarily mean that the effect of the information sharing isn't persisting for a period and being reflected in prices.
Well, even if it is in fact the date of the end of the cartel,
Indeed.
People don't, as I perhaps a bit flippantly put it to Mr. Raphael, wake up on the 1st of February and reduce their prices.
Indeed, Michael. But the submission I'm making here is part of my broader submission that judges is dealing with a different issue here. He's not accepting price persistence for the purpose of the counterfactual. And there's a good reason why he's treating it in this way. And you see it from 134, and where he sets out Dr. van der Laan's the evidence on price persistence Dr. van der Laan had collated, and then he sets out the quotation, which begins with words, he concludes that. So he's quoting the conclusion that Dr. van der Laan reached in his second report based on his statistical analysis of price persistence. And the statistical analysis was being deployed at that time in support of the submission that the effects of the cartel will likely have persisted. So that's the context in which the evidence was actually developed, and that is the context in which the judge is dealing with it.
And I asked Mr. Raphael about the relevance of this graph, because I couldn't see particularly the relevance of the graph to the point that he was making about price persistence of the type that he was talking about, which you say is not the right type.
Yep.
What is the relevance of this graph? Does it, to the price persistence that you say the judge was dealing with, is it that there wasn't suddenly an immediate drop in the two lines at the end, at the yellow mark January 06?
No, so
What is the relevance of this graph to this point?
So the graph, the y-axis on the graph, one thing to be aware of is that's using a log scale. So it's compressing the values that are used on the y scale, which means that the extent of the variability in the prices is not being fully represented in this graph. You can see a better version of what prices were doing earlier in the judgment. The judge is quoting this here because I believe this graph is in VDL2 when he introduces his analysis of price persistence. But the much better illustration without a log scale of what prices were doing is at, starting at page 75 of the core bundle. So you'll see it below paragraph 62, there's a chart that's undertaken. That's part of Dr. van der Laan's straight line model. But the bit that's not shaded is outside the cartel period. So it predates the cartel period. And you see what prices are doing in that period. So this is a period of time where there isn't a cartel. But you see the prices varying in a waveform over time. So the graph that's at, the chart that's at 134, my lord, for my purposes, it's not informative. It's just a graph that was put in VDL's evidence, Dr. van der Laan's evidence, in which the judge is then extracting when he comes to deal with.
Yeah, but sorry, my question is really designed, why do you think the judge is using that graph in the middle of this discussion, which you say is limited to the question of, is there price persistence at the end of the cartel because the cartelists don't return to competitive behaviour for a period? Well, I don't quite at the moment understand how the graph shows that, other than that there was no sudden drop in the lines.
The graph doesn't show it. The analysis that shows it is a different form of analysis, and the judge extracts the results of that analysis in the paragraph that's under the chart. It may be helpful if I show you what Dr. van der Laan actually conducted in terms of his analysis of price persistence to put this paragraph in a bit more context. I'll just bring up the reference, if I may. Yes, so it's Dr. van der Laan's second report, chapter 4, which begins in the supplementary bundle, tab 8, page 436. I'll just get to it myself. My lord will see firstly from the heading, chapter 4 is dealing with Mr. Parker's reliance on data for the post-cartel period. So that's what the evidence is being addressed to. And then the relevant section of the evidence is at 4.3, which is page 438, where you see persistence of pricing. And you'll see from 4.3.1 that in his previous report, I had explained why prices will not immediately return to the competitive level after the end of the cartel. So that's the issue that's being addressed in this section. He conducts a statistical analysis, my lord. Over the page, you will see the chart that's extracted in the judgment. But the tests he conducts are set out in 4.3.5 to 4.3.7. And the results of those tests are set out in 4.3.7. Now there's an oddity to note about what the results were actually showing. Because if you see, the results of the statistical tests, subparagraph A, for monitor panels, lags of 1, 2, 7, and 9 months are statistically significant at the 5% level. This means that the price for an LCD panel for a monitor in month T is partly determined by the prices in the prior month and prices 2, 7, and 9 months in the past. Now, if we just stop there, why should that be the case? What is the magic in 1, 2? You miss out 3, 4, 5, 6. 7's included, 8 goes, 9 is included. But that's what the statistical analysis is showing. And for notebook panels, there's a similar type of result. But here's the conclusion on the opposite page. These results indicate that the effects of the cartel will likely have persisted in both LGD's monitor and notebook panels for at least 6 months after the end of the cartel period. The implication of this is that Mr. Parker's model will provide an underestimate of the overcharge. So the evidence is being deployed to make that point. And he's extracted results from a statistical analysis. And that is what the judge is referring to and quoting in his judgment at 134. So returning to the judgment, we're at page 99 of the core bundle. And we dealt with paragraph 134. The judge then goes on to set out some more of the evidence and some of the points about what was said in the joint statement. Mr. Raphael took you to passages of 135 and 136. And then we've got 137, where the finding is said to be made. And the judge, it's fair to note, states that he thought Mr. Parker had made a change of position and he wasn't accepting the change of position. But if you go to the passage halfway down paragraph 137, beginning with the words, "I conclude that," where the judge is reaching his view, I conclude that the inherent probabilities are, as Dr. van der Laan says, and that it will be unusual, both unusual and highly unlikely, that the effects of a worldwide price-fixing cartel could be eliminated instantaneously on the coming to an end of the cartel. So let's just pause there. It's the inherent probabilities that are being accepted by the judge. That's what's doing the work in 137. He goes on to elaborate. That said, I do not think the post-cartel price effects are capable of calculation with precision by reference to the statistical analysis that Dr. van der Laan has used. But to be clear, I do accept that analysis strongly supports the inherent probability that the effects of the cartel, the inherent improbability, that the effects of the cartel came to an end at midnight on the 1st of February 2006. So the work in this reasoning is being done by the inherent probability. The statistical analysis is not being accepted for any wider purpose. The most that can be said is that it's supportive of an inherent probability. Now, the judge then, having taken this view that there's an inherent probability, he needs to come to a conclusion on, well, how long is this post-cartel effect likely to have lasted? At 141 is where he addresses this. And even on this issue, you'll see from the first few sentences, despite quibbling with some of the evidence that Mr. Parker gave, the judge preferred Mr. Parker's view. So he said, Mr. Parker's view, that post-cartel effects attributable to price persistence would have ceased to apply after a period of 3 months from the notional end of the cartel. Notwithstanding my concerns, I consider his evidence on this particular point is to be preferred. And it's obvious why that might be the case when you saw the statistical analysis. Beyond the period of 2 or 3 months, the statistical analysis was suggesting quite odd results. So you have certain months disappearing and then reappearing. So that's how the judge is dealing with price persistence. Now, none of this, in my submission, demonstrates that the judge was obliged to use a 2 to 3 month price lag when modelling for the counterfactual.
Well, in fact, his conclusion is ceased to have a substantial effect by sometime between the end of May and the end of June. So that's 4 to 5 months, isn't it? Despite the point made about no statistical effects shown in month 4.
Yes. If I recall correctly, the end of the cartel was 1st of February.
Yes.
So it's between the end of May and the end of June, yes.
So you say it's apples and pears. One is dealing with the real world in which cartelists don't change their spots overnight. And the other one is saying in the hypothetical non-cartel world, do the prices that are charged by non-cartel manufacturers take time to adjust to other factors?
Indeed, my lord. Right. And he's not constrained. The argument that seems to be put is that because he's made a finding in this section of the judgment, he's constrained consistently with that finding to use a 2 to 3 month price lag model. And that just doesn't follow, given the nature of the findings he made. And my lord, on this point, the judge, when refusing permission to appeal, also states in his permission to appeal ruling that the 2 sections of his judgment are dealing with different issues. So that's PTA judgment paragraph 29, and it's core bundle tab 6, page 181. So there's nothing in this first point, my lady, my lords. The second basis...
Well, you're going to come back to paragraph 143 when you deal with the first ground of appeal, because the point against you is that he accepts that he has to make some adjustment to take account of post-cartel effects,
Yes.
but he applies the Asda's proposition and therefore didn't do enough.
Well, I will come back to that.
I'll come back to it when you deal with that, but that's definitely one you've got to address us on.
I will do. Can I just note for the time being, in the middle of paragraph 143, the words required to eliminate the possibility of under-recovery. And I'll come back when I address round 1 in due course to deal with all of the ASDA points. So that's the first basis of challenge, inconsistency. The second basis of challenge is, well, there was evidence that was enough for you to include 2 to 3 month price lags in a regression model. And essentially this point relates to evidence of long-term supply contract. Now, as a preliminary point, if one is relying on long-term supply contracts, so these are contracts under which the LCD manufacturers or cartelists agree to supply LCD panels to clients, if you were expecting a long-term supply contract to give rise to some form of price persistence, what would matter is the price terms of that contract. So what is the contract saying about price? It's not sufficient just that there's a long-term supply contract. You would need to consider what effect the contract is having on prices. And I think once that is appreciated, if one looks at the evidence to which Mr. Raphael took you, which, by the way, Dr. van der Laan didn't refer to when he put forward 2 to 3 month price lags, that evidence does not establish that the price terms of any long-term supply contracts would have meant the prices were fixed for periods of 3 months or persisting for long periods. I'll find the references. So the first document you were taken to is the Commission decision and recitals 45 and 46. So that's Supplementary Bundle, tab 20, page 1204.
Which supplementary bundle is that? Do you know?
I'll never find out. It may be at the end of your bundle 3.
Yes, I think it is.
So it's Supplementary Bundle, tab 20, page 1204. An emphasis is placed on recitals 45 and 46. So 45 is just saying that customers may conclude long-term contracts with suppliers. 46 is interesting because it's recognizing a separate pricing process. And just the last sentence of what's quoted, there's an account manager, they deal with customers, and you'll see the last sentence quoted, the buyer's target price is set based primarily on its own assessment of the then prevailing market conditions, i.e. supply and demand. So there's no evidence here in 45 and 46 that price terms are providing for prices to be fixed for a prolonged period of time. The second point that's relied upon is the evidence of Mr. Lim. That's Supplementary Bundle, tab 1, page 9. And it's paragraph 17 which was emphasized, but you should read 17 and 18 together. So it's dealing with LG's relationship with a particular customer, Hewlett Packard, and it's noting that both quarterly and monthly forecasted sales quantities would be the subject of separate individual price negotiations. And 18 goes on to note that the final price reached would depend on several other factors. So there's obviously a process going on. And in the last words of 18, and the relevant market conditions at the time. So none of this, and Mr. Lim gave evidence at the trial, and so far as I recall, it's not been put to him that his evidence is demonstrating that prices were being fixed for prolonged periods of time under long-term supply agreements. So 18 is in particular emphasizing relevant market conditions at the time. And one would expect that in a situation in which you've got this crystal cycle in operating the background, because, and from the curve that my lords saw, Dr. van der Laan's chart, where prices are going up and down in a wave formation, it's not commercially sensible for you to lock yourself in to prices for a prolonged period of time. It may work to your advantage, it may work to your disadvantage, but you want to leave yourself the freedom to negotiate on price depending on market circumstances that are prevailing. And that's how these contracts appear to be structured. We've got a long-term supply agreement, but there's an ability to negotiate on prices within that. So, putting this in context, it needs to be demonstrated that there was evidence before the judge which obliged him to use a 2 to 3 month price lag model. Now, for that to be the case, you need some pretty clear and unequivocal evidence that the price terms of long-term supply contracts were providing for prices to be set for prolonged periods of time. And this isn't that type of evidence. Although the final point that, if I recall correctly, was emphasised is Mr. Raphael took your lordships to the judgment paragraph 193. And that's page 116 of the core bundle, line tab 5. I think some emphasis was put on the last sentence on that page, where the judge is recognising whilst long-term contracts are likely to have been a feature of the upstream market. But he's not saying anything about price terms. So, my lord and my lady, if you're with me on those submissions, then ground 2A has to fail because there's no basis upon which the judge's reason that was insufficient evidence of prices being lagged in the counterfactual to justify the use of 2 to 3 month lags in regression modelling. Neither his findings in the later part of his judgment nor those documents demonstrate the lag that is supposed to be modelled for in the counterfactual.
Can you explain or unpack what the judge is referring to at paragraph 111, at the bottom of 91 and the top of 92, where he says that Mr. Parker had tested his model using a lag price variable and had concluded that it should be rejected?
So when Mr. Parker developed his regression model in his first report, he also conducted a number of sensitivities to that model, seeking to test it. One of the sensitivities which he conducted was to use a 1 month price lag in the model. So Mr. Parker didn't just have his baseline model and nothing else. He had tested it in various different ways. I think there are 15 different sensitivities he performs. But the judge is referring to that evidence that Mr. Parker had already considered price lags, albeit for a period of 1 month, and found that that led to problems in the way the model was operating. And that's, I think, what the reference in 111 is addressing.
So is that at his initial, and for him, critical stage of getting what you regard as the right economic indicators to put into the model?
Indeed, my lord. It's at the stage when he's first putting together his model. That's 1 month price lag. He doesn't think there's a justification for including them. What subsequently happens is after Dr. van der Laan gives his statistical evidence on price persistence for the post-cartel period, there's a joint memorandum that's produced, and I think you were taken to that by Mr. Raphael. There's a proposition 20 in the joint memorandum, which is dealing with post-cartel effects, but in there, Mr. Parker says, well, I think that at most, Dr. van der Laan's analysis is showing price persistence for 2 to 3 months. Now, that's in the context of post-cartel effects. But Dr. van der Laan then adopts that, what he perceives as a concession, to introduce a new model in his third report, BDL3, which includes 2 to 3 month price lag in the regression. So that's how the sequence of events occurs. Mr. Parker had considered lagging variables in his first report. It was for 1 month. I want to be accurate. It wasn't for a period of 2 to 3 months. But then that type of change had already been considered. The 2 to 3 month model emerges in September when we've got the trial in October, and it's after the joint statement has already been produced. That's how the history unravels. And Mr. Parker then addresses the 2 to 3 month lag model by way of further reports, and he says, "Oh, I still don't agree with this because it's not. You're not using the right explanatory variables in this model if you're introducing a 2 to 3 month price lag."
Can I just? We're here at the moment, ground 2A, talking about lagged panel prices.
Yes, my lord.
Or lagged dependent variables. In other words, the question is whether the price charged for the LCD panels is sticky. Is that an expression that's used occasionally, i.e. that it doesn't instantaneously respond to whatever factors affect the manufacturer fixing the price.
So
to give the example you've just been exploring about long-term contracts, there was no evidence of the terms on which long-term contracts would in any way inhibit a manufacturer from changing the price of the panel overnight if it woke up that morning and decided it wanted to, or in response to some event. That's what we're talking about. Yeah?
Indeed, my lord. So
why? And I still don't. I appreciate you may say I don't need to know the answer to this
yes.
for the purpose of this appeal, but
yes.
Why would incorporating a lag of that type into the panel prices change the level of overcharge materially? I still don't understand the logic to it.
I'll have a first go at the logic, my lord, and see if this is this. So when you're introducing price lags into the model for 2 to 3 months, you are saying that prices in the previous month are having a causal effect on the current price. Prices in the month 2 months ago are also having a causal effect on current prices. So you've got a 1 month lag, a 2 month lag, and then in respect of monitors, there's a 3 month lag. Sorry, notebooks, I'm corrected. Your prices that were set at the end of the previous quarter are having an effect on your current prices. So the price lag is being used as an explanatory variable. Now, why does it lead to the overcharge estimate changing significantly?
Sorry, I thought that was ground 2B, deals with price lag with explanatory variables.
Well, no, my lord. So the price lags, so price here is being used as an explanatory variable. So under 2A, what one is doing is saying that today's prices are causally influenced by prices in the previous period. So you introduce the price lags as an explanatory variable in the regression model. So you're saying that historic prices are having a causal contribution to today's prices. And that's why long-term supply agreements with fixed price terms might be relevant, because the prices that you set in previous periods might be affecting the price today. So under 2A, price lags are being used as an explanatory variable.
It's not what 2A says.
I can go back to that.
I don't think it is, unless I've just misunderstood. I mean, 2A says the judge made an obvious error in finding that regression models, including a lag-dependent price variable, shouldn't be used in the estimating, whereas ground 2B complains that you should have used lag-explanatory variables.
I think that may be an error of description. I'll be corrected if I'm wrong. But price is being used as an explanatory variable in the 2 to 3 month price lag model. I'm not corrected.
I did see a shaken head from Mr. Cockerill.
the dependent variable is price, and so you're including a lag of the dependent variable in the explanatory variables. I agree that could have been slightly more clearly phrased in that ground, but it becomes clearer in the skeleton. It's a lag of the dependent variable, which is then an explanatory variable. So it's a little bit of, maybe I should use the word of in that bit of the ground.
The key point, my lord, is that explanatory variables in a regression model are the variables that you expect will influence today's price.
The dependent variable.
Yeah. And past prices there are being used as an explanatory variable in the model. So what you're testing is the hypothesis that past prices are causally influencing today's price. And that's why the 2 to 3 month price lag model exists.
Or at least they're causally linked anyway, because people don't want to change them instantaneously. So when you're deciding what to do to respond to various factors, the price you charged last month or the month before are part of your thinking.
So that's the point on ground 2A. But our answer is that there's just, the judge is entitled to reach the view that there isn't evidence demonstrating.
But why does that factor change the overcharge number so significantly? I'm afraid I still don't get it.
Yeah. So I can try and explain, and I can see if we can come up with a further explanation overnight if it would assist my lord. But my understanding is, because you are using historic prices as an explanatory variable in the model, those historic prices that you're using, i.e. previous month and month before, will themselves incorporate a bit of overcharge. So the model is having a compounding effect over time, which is resulting in the overcharge estimate increasing. Now, I'll see if we can provide a better, more accessible explanation for why the figure is increasing. But Mr. Parker's short point is you don't include explanatory variables unless there's a good justification for doing so, actually, because that's the first and main question you ask. Otherwise, your model is not going to be producing results that are sensible and reliable.
But I thought that, sorry, I'm struggling with this again. I thought the model was trying to model what would happen in the counterfactual in which there is no overcharge.
That's correct, my lord.
So why does the answer, well, it compound if you...
It's about the unexplained effect. So that the model is seeking to ascertain what prices will have been in the counterfactual, and the difference between prices in the counterfactual and in the factual is identified as the overcharge. I'll try and get a more accessible explanation of why the figure is increasing so significantly. But on ground 2A, my short answer is that the judge was entitled to reject the use of a 2 to 3 month price lag for the principal reason he gave. The judge gave additional reasons for why.
Just before you deal with them, you've shown us the evidence of Mr. Lim, which is just a paragraph or two about long-term contracts. Was there any disclosure of your client's actual long-term contracts? Was that disclosure ever requested, for example?
I don't know the answer to that. I was only involved at a later stage, but we can seek instructions on that issue.
Well, if long-term contracts is becoming quite an important issue, I think I would like to know whether there was ever a request for disclosure of them, and if so, what happened about it?
Certainly, my lord, we can seek to ascertain the answer to that question.
Yes, thank you.
So, my lord, that's ground 2A, the judge's first reason, which we say is dispositive because it's not. He was entitled to reach the view he did. the judge gave further reasons for his conclusion that the 2 to 3 month price lag should not be used. And it's summarised in paragraph 115 of the document. It's page 93 of the core bundle. And I'm saying accept that mathematically lagging in the manner adopted by Dr. van der Laan reduces significantly the extent to which Mr. Parker's model treats input costs and demand as determining price. Whilst in principle that may suggest simply that cost and demand are not the main drivers of price in the LCD screen market, that is contrary to what has been agreed, is counterintuitive given the manner in which the crystal cycle operates in relation to demand, and is logically inconsistent. Now, the judge is there deciding to reject the use of 2 to 3 month price lags for an additional reason, which is the impact of the use of the lags on other explanatory variables. That's one of the points that Mr. Parker made that you should consider when deciding whether to make an adjustment. As I understand it, that reasoning, the additional reason that the judge gives, is not impugned under ground 2A. Provides a separate basis for upholding the judge's conclusion that he was going to reject the use of 2 to 3 month price as an explanatory variable. My Lord, that's ground 2A. I'm now going to turn, if I may, to ground 2B. And if I can invite the court once again to turn up the grounds of appeal. It's core bundle tab 1. It's at pages 18 to 19, and just invite the court again to read paragraph 6 and 7. Now, ground 2B was not developed in Mr. Raphael's oral submissions, but I don't understand it to have been abandoned, so I will deal with it. But there are two separate points being made here. The first in paragraph 6, that, as we shall see, is an attack on judgment paragraph 109, which is where the judge gives these two reasons in his explanation dealing with the second adjustment to the amended Parker model. Paragraph 7 is arguing that the judge should have specifically adopted a particular model which results in a 13.3% and 9.8% overcharge. And that model, my lord, is a model that's contained in Dr. van der Laan's second report at table 21. So just that's supplementary bundle, tab 8, page 473. it's also included in the aide memoir. Now let me deal with those 2 points separately. So I'll start with dealing with the paragraph 6 point, and then I'll deal with the paragraph 7 point. On paragraph 6, in my submission, the criticisms under paragraph 6 are just based on a misunderstanding of what the judge was actually addressing in his judgment at paragraph 109. He was there discussing, as I submitted, a possible variation to Mr. Parker's model that included 1 month lagged explanatory variables in addition to current explanatory variables. It's the second change made by the amended Parker model. And the reasons the judge gives for rejecting that change are correct. The 2 reasons he gives, and it may be helpful to have judgment paragraph 109 in front of you, which is core bundle, tab 5, page 91. So, approximately halfway down the paragraph, the judge says he did not apparently advocate for such an approach if the regression models used continue to incorporate semiconductor billings as the data used for the demand variable. And the judge says that's unprincipled. The second point he makes is it's worth noting, however, that lagging the explanatory variables in the manner suggested by Dr. van der Laan only results in a significant increase in the likelihood of a charge figure based on regression if the more general demand proxies that I've rejected as inappropriate are used. So it gives those 2 reasons. Now, just for your note, I dealt with this point in my skeleton of paragraph 27, so that's for your note, it's core bundle, tab 14, page 297, where I set out the evidence references, which I will take you shortly. As to the judge's first reason, it can be seen from Dr. van der Laan's second report at paragraph 6.1.8b, and that's supplementary bundle, tab 8, page 472. So the relevant passage actually starts at 6.1.8 on the preceding page, where Dr. van der Laan refers to the model that Mr. Parker is using. I may have an erroneous reference here, my lord. I'll just find the correct reference. Yes, it's 6.1.8b. Mr. Parker rejects the use of lagged values for demand, capacity, and costs for reasons set out in Parker 1 Annex F. In particular, Mr. Parker rejects the use of lag costs in his model because the results of his model incorporating such lag costs are counterintuitive and appear wrong. It gave very different effects for notebook and monitor panels. Now, Dr. van der Laan doesn't dispute that. What he says is, however, I note that these counterintuitive results do not arise in the amended version of Mr. Parker's model with the aforementioned change relating to the demand indicator. So what he's saying is he's acknowledging that the problem exists, but the problem doesn't arise if you also make the change to the demand indicator. So the judge is correct in saying that Dr. van der Laan did not apparently advocate such an approach if the regression models used continue to incorporate semiconductor billings as the data for the demand variable. My lord, as to the judge's second reason, which is that such an approach only resulted in a significant increase in the likely overcharge if the demand variable was changed. You can see that from 6.1.4. That's at page 470 of the bundle. And Dr. van der Laan explains the results of the changes he's making. I explained above that the estimate of the overcharge used in Mr. Parker's model increased to up to 17.6% for monitor panels and to up to 14.7% for notebook panels, depending on whether GDP growth or business confidence is used to indicate demand. By adding a lag to some variables, the overcharge estimates increase to up to 20.9% for monitors and up to 17.9% for notebook panels. So the large majority of the effect is coming from the change to the demand indicator, not from the introduction of lagged explanatory variables.
Is that right? I mean, if you look at the Aidman one, which has the summary of all these, as I understand it, the change to baseline Parker, which is where the judge, give or take, ended up with a little bit of add-on, would take you from 5.7 for semiconductor billings for notebooks to 13.3. I think we're looking at the lagged costs of the 13.3, the sixth one down.
My lord, that's the model relied on in paragraph 7. I'm going to be coming to that shortly. The key thing to note about that,
Okay, but
if you look at sensitivity on the side, the description of the model, that's using lagged costs instead of current costs and lagged capacity instead of current capacity. Whereas what we're dealing with here are lagged explanatory variables in addition to current explanatory variables.
But those figures don't appear on the aide memoir at all, do they?
Sorry, my lord, I maybe which figures?
Well, 6.1.4, I think you said.
Yes, they don't.
Those figures don't appear on the aide memoir, so from which I
actually they
infer
do.
that they're not pressed.
Well, sorry, the 6.1 before those figures do appear, don't they? Aren't they the ones in the, if you change the demand indicator, aren't those the figures that are in the second and third columns across? 17.6, 14.7 and
the 17.6 and 14.7 don't appear, as I understand it.
No, they're in the third column, the business confidence column, aren't they?
Yes, I see. Yes.
But I thought what the judge was saying in 109 was that, and you may be right about the costs instead of, as opposed to in addition to, but I don't understand how you use them in addition to. That defeats my understanding. But if what the judge was saying is that the sixth row of numbers down in the semiconductor billings column is not materially different, he says, even if lagging the explanatory variables in the manner suggested by Dr. van der Laan only results in a significant increase in the likely overcharge figure based on regression if the more general demand proxies that I've rejected as inappropriate were used. And so he's restricting himself to the semiconductor billings column. And the only, as I understand it, what Dr. Van was suggesting was the sixth one down in relation to lagged cost and lag capacity. And if the judge was saying, well, the only difference is it turns it from 5.7 into 13.3 or 2.4 into 9.8, I have a little bit of difficulty saying that that's not significant, because on the face of it, that would, triple or close to triple or quadruple the overcharge, wouldn't it?
So that's not the context in which the judge is making the point. So the judge is making this point in the context of the amended Parker model. The amended Parker model is the model at the next large row down. And what the judge is talking about is
the amended Parker model, the green lot, doesn't appear to have a sensitivity, change for lag costs or anything else, does it? I suppose it does. Yes. I suppose it does. It is. Yeah, no, you're right.
And what the judge is referring to there is the move from the rows immediately above the red box. So you've got 17.6, 14.7, moving down to 20.9 to 17.9. And similarly, in relation to GDP growth, 14.7 to 13.9, going to 18.1 to 17.7.
I'm still not sure I follow that, because he says he says you only get a significant increase in the likely overcharge figure if something happens. Now, his bottom line that he's comparing the increase to is the one on the Parker baseline model, isn't it?
No.
No.
Is he looking at the boxes under amended Parker model, but in the semiconductor billings column, where the figures go from 5.7 to 5.5 for monitors, so the overcharge actually reduces if you have both lagged and current controls, and the notebook figure 2.4 is exactly the same. So that's not significant, and if anything makes things worse for the claimants. Whereas if you adopt the indicators which he has rejected, GDP growth and or business confidence, you do get a significant increase. Is that the point he's making?
The way I've interpreted it, my lord, is that the judge is dealing with a situation in which he's comparing the situation in which you include the demand variable in the revised demand variable in the regression model. So instead of using semiconductor billings, you use GDP growth or business confidence.
But he's rejected that.
Yeah.
He's rejected that already. He's saying here, well, if you bring those things I've rejected back in, and you add lagged and current controls, then you do get a significant increase. But I'm not going to go there because I've already rejected.
And he's definitely
those
working from a
things.
baseline of the 5.7, 2.4 figure, because when he gets into paragraph 110, he then says you get this movement from 5.7 to 30.1. It seems to me that it makes best sense to read what he's saying, that there is only a significant increase as more general demand proxies were used, and without that there's no material effect. As says, Lord Justice Mail says that the initial figures that he says makes little difference is that 5.5, 2.4, and then you get into the other figures for the amended Parker if you change the other variables.
I think if the judge is saying what my lady has suggested and what I've tried to suggest, then his judgment makes sense. If you read it some other way, then it doesn't.
Confused.
Therefore, and I hope this is not reverse engineering, he probably is saying what my lady and I think he's saying.
You may be right about that. That was paragraph 6 of ground 2B. I'm going to turn to paragraph 7, if I may, which is dealing with a different model, and that is the model which Lord Justice Snowden adverted to. So it is producing the figures of 13.3 and 9.8. And it's lagged costs instead of current costs and lagged capacity instead of current capacity. And you'll see from grounds of appeal, paragraph 7, that those are the figures that are being quoted.
The reason I was focusing on those numbers was because paragraph 7 says the judge therefore should have adopted. In other words, going back to paragraph 6, I thought paragraph 6 was effectively saying that the judge should have ended up in the box 13.3 and 9.8. And I understand why he would say that you do get a material change from his baseline, the baseline 5.7 and 2.4 in the top left-hand corner red box. You do get a significant change if you change the demand indicators to GDP growth or business confidence, which he has rejected. I understand that's what he's saying. But what he seems to be saying is you only get a significant change if that's what you do. And I can't quite understand that because there seems to be the 13.3 and 9.8 in the very same semiconductor billings column.
That's correct, my lord. But
and so that's my sort of problem with trying to dissect paragraph 109 or indeed 6 or 7 of the grounds of appeal.
The critical point is that the 13.3 and 9.8 figures arise from a model that replaces current costs and current capacity with lagged costs and lagged capacity. So the other lagged models are including both lagged and current controls. So what you're doing is you're not including current costs and current capacity at all in the model. So it's perhaps easiest to see it from the model itself, which is in Dr. van der Laan's second report at table 21. It's supplementary bundle tab 8. And it's at page 473. So it's results of sensitivity tests, replacing contemporaneous costs and quarterly change in glass substrate capacity with their lagged versions. So he's removing contemporaneous costs and capacity and only using a lagged version. So the hypothesis on which this sensitivity is based is that prices are not affected by current costs or current capacity, but only by previous costs and capacity. And it's a 1 month lag that's introduced. Now, the answer to this point, why the judge is entitled not to accept this model, is that it's based on a premise which is inconsistent with Dr. van der Laan's own evidence at trial. So his evidence at trial was that he positively disclaimed reliance on models that included lagged variables instead of current variables. And if I can just show you the transcript. It's supplementary bundle tab 40. And page 1565 is where we start. And the relevant passage starts at page 116, line 9, and it goes on to page 117, line 13. Now, it's in the context of a different model, but the same point of principle is being put to Dr. van der Laan. He's accepting, well, he's agreeing that it doesn't make any sense that a company would only care about conditions in the past and not current conditions. And he's accepting that it's, from an economic perspective, it would be highly unlikely and very implausible that a company would price its decisions only on lagged control. So Dr. van der Laan's position at the trial was, you shouldn't be doing that. He's included a model which does that in the aid memoir, but it's not one that he supports.
Was there then a submission in closing that the judge should accept this model?
I don't understand this model to have been referred to at all in closing.
Had a quick look and I couldn't see anything.
I mean, if it wasn't referred to, then we would say paragraph 7 is a bit tough on the judge.
I entirely agree, Michael. This is the judge's point. When I was making my points about the nature of the grounds of appeal, One of the points I included was the appeal was telescopic in nature, and also the judge complained in giving his permission to appeal ruling that there'd been an ex post facto review, and points which weren't emphasised at trial were being deployed in the grounds of appeal. And this model was not one that was being urged upon the judge. And it couldn't have been because it's inconsistent with Dr. van der Laan's evidence on the substantive issue, which is, should you only be using lag controls instead of strong control?
Right, is that 2B?
That's to be done, my lord. I then turn finally to 2C. And my lord, I'll take the same course if I may, which is to start with the grounds of appeal document. And it's pages 18 to 19. Paragraphs 8 to 11. So, my lord, there are essentially 2 points that are being made. Paragraph 8 is the point that Mr. Parker's model was not robust to reasonable adjustments to its specification. And paragraph 9 is dealing with the alleged inherent implausibility of the overcharge estimate, which is inconsistent with other factual indicators. And the only specific indicators that are mentioned are the overcharge levels in other cartels and inconsistency with the $100 increase in LCD panel prices at the start of the cartel. And paragraph 11, the judge should have given weight to the alternative modelling and adopted a different and higher overcharge estimate. So there's a challenge to weight. If I start with robustness and reasonable adjustments to specification, and make 3 preliminary points. The first is, as I've already shown the court, Mr. Parker had given evidence on the relative significance of factors when assessing the robustness and validity of a model. And his key point had been that the most important thing is to identify the right explanatory variables based on an accurate understanding of the factors that will affect price. Secondly, before the judge, Dr. van der Laan was making criticisms of the robustness of Mr. Parker's model, was still maintaining that the court should accept his price trendline model. Thirdly, the judge considered the difference between the experts on the relative significance of statistical tests and the identification of explanatory variables which are well supported. And he reached the view that he preferred Mr. Parker's evidence, which is a view he was entitled to reach. Now, the mere fact that the overcharge estimate produced by a model changes when you change the explanatory variables is not telling you whether it's a robust model or not. The critical question is whether the change you're making, the explanatory variable you're using, is well justified. That's Mr. Parker's evidence. Now, what are the reasonable adjustments that the appellants rely upon? Well, in submissions, Mr. Raphael emphasised 3 points. So the first was modelling a change to the demand indicator, so using GDP growth or business confidence instead of semiconductor billings. Because if you make that change, then the results of the model differ. But the judge has considered whether that is a valid change to make or not in his judgment. And he's reached the view that he shouldn't make any such change because it's not well justified. So there's no basis upon which to challenge the judge's conclusion on grounds of robustness. The fact that you make an inappropriate change to the model results in the overcharge estimate. The second point that was relied upon was if you change the model to use absolute level of demand rather than change in demand, that leads to a change in the overcharge estimate. But that isn't an adjustment that Dr. van der Laan himself emphasised at the hearing. So we've seen that the two that he picked out from his aide memoir were the amended Parker model and the 2 to 3 month price level. And the final adjustment that's relied upon is the use of lagged prices. If you introduce lagged prices into the model, it results in a change in the overcharge. But the judge gave reasons as to why the use of 2 to 3 month lag prices was inappropriate, and we've dealt with those under ground 2A. So these points really just recycle models that the judge was unpersuaded by in light of Mr. Parker's evidence. So there's no basis in my submission, in light of the evidence that was before the judge, to say that he reaches findings that are not open to him because the model put forward by Mr. Parker was not robust to those adjustments to its specification. Can I address implausibility due to inconsistency with other factual indicators? So that's paragraph 9 of the grounds of appeal. Now, the starting point here, as we've addressed from the outset, is when assessing the overcharge, you're conducting an exercise which involves constructing a counterfactual world in which the infringement did not take place and comparing it to the actual, so the world in which the infringement does take place. And you're seeking to identify what the difference in prices will be. That is an essential starting point for when one addresses the significance of factual indicators. Now, the first point that's made, or the first point I address, is the alleged inconsistency between the judge's finding and the US $100 increase in panel prices at the start of the cartel. Now, Mr. Raphael's skeleton at paragraph 42 of paragraph 1 makes clear that he's relying on a price increase in the period between January and October 2002. That's core bundle. Tab 2, page 34. But the short point here is that there's no basis for assuming that that price increase was caused by the cartel. And indeed, there had been other similar price increases outside of the infringement period, which could not have been caused by the infringement. You can see that, for example, from the chart I took you to at judgment paragraph 62. Well, the graph is showing significant increases in panel prices over a short period of time outside the infringement period. Second point that's made on inconsistency with factual indicators is that the judge misdirected himself as to typical levels of overcharge in other cases. And Mr. Raphael Skeleton clarifies at paragraph 43 that what he's referring to here are studies of the level of overcharge in other cases. That's just for your note, it's core bundle, tab 2, pages 34 to 5. Now the judge, this is an unfair criticism, judge. I can take the court to the judgment, core bundle, tab 5, starting at page 73. So, paragraph 57 says, Dr. van der Laan placed some reliance on an academic study of previous findings made in relation to other cartel claims over many years. He sets out some of the results of that study. And the final sentence of the paragraph, this needs to be borne in mind when considering this work, to the extent that it is material to the issues I have to decide, a question to which I refer below. The judge is setting out what he understands the study to reveal, but he's qualifying it by saying this needs to be borne in mind to the extent that it is material to the issues that I have to decide. And he indicates he's going to address the question of materiality later on. Paragraph 58 deals with another study, which is the Obsera study relied on by Mr. Raphael. And again, we have a similar formulation. Point that emerges is that the overcharge, the judge sets out the result he thinks emerges, but in the final sentence in 58, thus, to the extent this material assists at all, again qualified, it suggests as improbable or at any rate highly exceptional an overcharge of the level contended for Dr. van der Laan. But then the judge addresses his qualification in paragraph 59. He says, more fundamentally, however, I consider it wrong in principle to use historical data derived from other findings by other courts and economic studies in relation to other cartels. So he's reaching the view that this material is not assisting him. It's wrong in principle to rely upon it. And he confirms it at the bottom of the paragraph on page 74. More to the point, however, for present purposes, it is not in dispute in this case that the cartel had adverse effects in the form of at least the overcharge acknowledged by Mr. Parker. These studies say nothing about how the quantum of overcharge should be assessed or at what level they should be assessed, which, as I have said, is a fact-sensitive question in every damages claim that depends upon the evidence employed in the particular case. So he's not placing reliance on those studies, let alone misdirecting himself as to what those studies show. He considered rightly that he had to look at the facts of this case and to decide what the level of the overcharge was in this case. The final matter that was relied upon in submissions was a reference, I think, that was made to the Court of Appeal's judgment in the Royal Mail case. And if I can take you back to that. It's in the Authorities tab 21. That page 1299, I think, is where it begins. I apologise, it's page 1320 where it begins. Just for context, in this case, the tribunal from which the appeal was being heard had found a 5% overcharge in relation to the trucks cartel. So the comments that are made by the Court of Appeal in this case should be understood against that context, so the context of a 5% overcharge, which is lower than the overcharge found in this case, 8% on monitors, broadly equivalent to an overcharge on notebooks, 4%. And if we turn to the relevant passage, it begins at page 1368. This is where the relevant ground of appeal was being addressed. And the court introduces ground one. The logical consequence of that case was the counterintuitive proposition that the claimants had failed to establish there had been an overcharge at all. Understood counsel to resile from that submission. He still submitted that the CAT had not been entitled to conclude that the loss was sizable or substantial. So the sizable or substantial reference there is to the 5% overcharge that's made, that's determined by the tribunal. And it's in that context that one considers the observations that are made at paragraphs 140 to 142. And in particular, the point at 141, that in the circumstances, the CAT was entitled to proceed on the basis that there was an overcharge, and that it was substantial, not minimal, as Daft's case would suggest. So nothing in this judgment is setting out any principle by which you can determine the amount of the overcharge by reference to the conduct itself. We're just relying on a sense check here. And the court is itself, when it's referring to substantial, not minimal overcharges, is doing so in the context of a 5% overcharge. So there's no inconsistency between the judge's conclusion in our case and what the Court of Appeal is saying in Royal Mail and Daft.
Well, a 5% overcharge may or may not be significant. Depends on volume of sales, what the prices are, 5% of what, and all the rest of it, I thought.
It's something that has to be assessed on the facts of a particular case. One can't draw an inference as to what the particular level of the overcharge will be by reference to these matters. So one can't decide that I'm expecting an overcharge of X% as a result of the type of conduct that's occurred in a particular cartel. The assessment of the size of the overcharge itself is a matter of empirical evaluation, and the way you access that is to try and test it empirically.
But at a more general level, isn't it reasonable to say that a cartelist would only be likely to engage in that illegal conduct with all the risks involved in that if it's going to be financially worth its while to do so, because the likely reward is sufficient to outweigh the risks?
It is reasonable to say that, my lord, but there's no inconsistency between that and the judge's conclusion in this case. So the context in which the Court of Appeal is making that point is in the context of an argument where under ground 1, DAF appeared to be saying that an overcharge hadn't been proved. The tribunal concluded that there was a 5% overcharge. And so the observation that the CAT was entitled to proceed on the basis that it was an overcharge and it was substantial minimum is given in that context. There's no principle of law being established about you're being able to ascertain the particular level of the overcharge by reference to the nature of the conduct in issue in a particular cartel.
I mean, so you say, look, if the argument is to the effect that respectable cartelists don't get out of bed for less than 5% or less, then you'd say, no, you just don't know.
Don't know. And so,
you've got to come to a number one way or the other. If it came to be 0, then you might begin to have a question mark. But who knows whether 5%, 10% or more is the right number.
Exactly so. And there can be circumstances where, even though there is a cartel, there's cheating going on. So whilst there may be an appearance of coordination, actually there are limits on the cooperation. It's why it has to be tested in order to work out what the estimate of the overcharge is. But my submission is this isn't a basis for disturbing the judge's conclusion on overcharge. And my lord, those are my submissions on ground 2C. And I say for all those reasons, ground 2 of the appeal should be dismissed. I had some respondents' notice points that I had raised. If I can just clarify the position in relation to those. So, the respondents' notice is in the core bundle. At tab 13, page 280. So, Respondents' Notice 1 is dealing with the judge's additional reasons for rejecting a model incorporating lagged panel prices. But as I say, on analysis, the judge's additional reasons are not impugned under ground 2A. Respondents' Notice 2 is dealing with the inconsistency in the findings. And the premise of that is if the court concludes there is a relevant inconsistency. But it's not necessary for me to pursue that because I've made my submissions on why there is no relevant inconsistency between the judge's conclusions on price persistence and his approach to the 2 to 3 month lagged panel prices. And Respondents' Notice 3 is just seeking to incorporate the additional evidence that Mr. Parker gave in relation to regression models incorporating other lagged explanatory variables.
I'm glad we've reached multi-collinearity because that's a new word for me. What's it mean?
So, my lord, the point that Mr. Parker makes is that when you lag a quarterly, a variable that's a quarterly variable, and you lag it by 1 month, you've got an overlap in data for a period of 2 months. So you've got a quarterly value based on the 3-month period, and you're lagging it by 1 month. That leads to a multicollinearity problem because the data is being replicated. 2 of the 3 months of the data is being replicated in the model. That leads to statistical problems with the model's output. If it would assist the court, I can take you to the parts where Mr. Parker deals with multicollinearity concerns.
No, I just wondered what the word meant. That's
Great.
If I don't need to know more than that, I'm happy.
I think it's explained at 513 of the supplementary bundle. You've just explained it.
If you've explained it, that's fine. You move on.
I don't think we need to go to it.
I'm grateful. So if I can turn then to round 3, which is downstream pass on. And again, invite the court to take up the ground of appeal document, which is Core Bundle tab 1, pages 19 to 20. And invite the court to read paragraphs 12 to 14 over the page. And you'll see there that in paragraph 14, the position is that is adopted in consequence of the errors that are alleged is that the judge should have held that no downstream pass-on was made out and that there should be no deduction from the loss suffered due to the overcharge as a result. So it's an in-principle attack on whether causation could be established at all. There's not an alternative under ground 3, which is saying, well, the judge was entitled to find that causation was established, but he should have assessed it at some lower level. And the natures of the error, in terms of the nature of the errors that are alleged, they fall into 2 broad categories. The first is the failure to satisfy the test of a direct and proximate causal link. And the second concerns the weight the judge attached to various factors on the evidence. So matters such as psychological pricing, for example, warranties, etc. I'll take my submissions in relation to ground 3 in the following order, if I may. I'm going to start with some submissions on the law on causation in relation to downstream pass-on. Secondly, I'm going to make my submissions on the question of proximity or legal causation. I'll make my submissions why, if the judge was entitled to reach the factual conclusions he did, sufficient proximity clearly existed in this case. And thirdly, I'm going to address the appellant's challenges to the judge's factual assessment, the downstream part of the namely their reliance on their criticism of the weight he applied to various factors. So if I can start then with the law. Now, pass on is a form of mitigation that avoids loss, and I make 4 points in relation to it at the outset. The first is that in considering pass on, the cases recognise a distinction between factual causation and legal causation, although that distinction is sometimes elusive. Secondly, as to factual causation, the question is whether the overcharge was in fact passed on so as to reduce the claimant's loss. And the cases do not limit the type of evidence that may be used by a judge to reach a conclusion on whether pass on occurred as a matter of fact. As with any issue of fact, economic opinion evidence and inference are relevant and permissible. Thirdly, as to legal causation raises a question of legal policy involving a criterion of directness or proximity. And my submission on analysis, the case is established that sufficient proximity can exist for a range of different reasons and are not prescriptive. In particular, the relationship between the product on which the overcharge is incurred and the product that's subsequently sold can be sufficient to establish the requisite degree of proximity. Fourthly, if causation is established on the balance of probability, in assessing the amount of the pass on, the court is entitled to exercise a sound imagination and the practice of broad tax. So in other words, the court does the best it can to arrive at the amount. Now, I'm going to take the court to a few cases. I'll start, if I may, with Sainsbury's and the Court of Appeal, and that's in Authorities, tab 10, page 700. And the relevant passages begin at page 774. And you'll see the subheading, should the CAT have reduced Sainsbury's damages for pass on. Then in paragraph 321, the Court of Appeal notes that the actual point in issue in the appeal was a narrow one, but it goes on to make some observations on how downstream pass on operates. At 324, we have whether or not the unlawful charge has been passed on is a question of fact, the burden of proving which lies on the defendant who asserts it. Over the page, 775, paragraph 330, sums which have diminished the loss are only to be taken into account if there's a sufficiently close causative link between them and the wrong committed by the defendant. And at 331, the Court of Appeal makes some observations about the operation of the broad acts principle in this context, or evidential considerations, which the Supreme Court later revisits in its judgment. If I can just show you 331, which is page 776, halfway or just over halfway down the paragraph, you see the sentence beginning, fourthly. Fourthly, we do not accept Mr. Hoskins' submission that the broad acts principle of establishing recoverable loss, which we have discussed in the context of the first quantum issue, applies to the burden on MasterCard to establish, one, the fact, and two, the amount of pass on by Sainsbury's. The broad acts principle is applicable where the claimant has suffered a loss as a result of the defendant's culpable conduct. There is a lack of evidence as to the amount of such loss. There is no scope for application of any such principle where the burden lies on the defendant. Now, as we will see, the Supreme Court rejects that analysis and says that the broad acts is available to a defendant as well. But even the Court of Appeal, in paragraph 332, is accepting that a wide range of evidence is in principle relevant to demonstrating causation. So on the other hand, we accept Mr. Hoskins' submission, then in each case it is a matter for the judge to decide whether on the evidence before him or her the defendant can show a sufficiently close causal connection between the overcharge and an increase in the direct purchaser's price. We see no reason why the increase should not be established by a combination of empirical fact and economic opinion evidence. It is not appropriate for us in these appeals to be more specific as to the nature and type of evidence capable of satisfying a trial judge that there is a sufficiently close causal connection. And just finally, in relation to this authority, over the page, paragraph 338, the Court of Appeal is addressing an argument that was raised about whether it's necessary to identify a class of sub-purchaser to whom the overcharge has been passed on. And they take the view, which is subsequently adopted in succeeding cases, that there is no such requirement. Now, the Supreme Court revisits this reasoning on the appeal. And that's the next authority to which I wish to take the court. And it's Authorities 1, tab 13. The case begins at 891. And amongst other issues, it was alleged by the appellants that the Court of Appeal has erred in concluding that a contention by a defendant that the claimant had passed on overcharge to its customers required proof of the exact amount rather than a broad axe estimate. The argument was that once it was proved there was likely to be some pass on, the extent of pass on could be estimated using the broad axe. And the Supreme Court accepts that analysis. If I can ask you first to turn up page 939 of the bundle. And you'll see at the bottom of the page there's a subheading, the broad axe issue. These issues concern with the degree of precision that's required. And at 176, which goes over the page, the Supreme Court quotes the part of the Court of Appeal's judgment which I've taken you, which was doubting or rejecting the application of the broad axe in favour of a defendant. At 178, the Supreme Court refers to the Court of Appeal's statement on relevant evidence. And it notes in 178, below the quotation, it is therefore clear that the Court of Appeal was not excluding any form of evidence as relevant to the establishment pass on, but was drawing a distinction between the degree of precision in quantification required of a defendant and that which was required of the victim of the wrong in establishing its claim. The questions which arise are whether there is a requirement in European law or otherwise as a basis in principle for that distinction. So it's the Supreme Court acknowledging as well range of evidence relevant to establishing the fact and extent of pass on. It's right to note over the page at 180, at page 941, paragraph 180, that the scope of the argument before the Supreme Court expanded, and they sought submissions on a range of issues, including legal and evidential burdens. And that's the reason why those issues come to be addressed in the judgment. Now, if I can take the court next, please, to page 946. In paragraph 205, the court identifies at least four options or four ways in which a merchant could react to an overcharge. And options 3 and 4 are reducing its cost by negotiating with its many suppliers. So cost reduction is in the context of negotiating with your suppliers, or passing on costs by increasing prices. And at 206, second sentence is important. But if there is evidence that they have adopted either option 3 or option 4 or a combination of both to any extent, the compensatory principle mandates the court to take account of their effect, and there will be a question of mitigation of loss to which we now turn. So even if you've got several different responses occurring in parallel, if there's evidence that either option 3 or 4 or a combination of both has occurred to any extent, the court has to take account of their effect and address the question of mitigation of loss. And then the Supreme Court turns to address that issue. 211, which is page 947. The court states that it's satisfied it's correct that the legal burden is on the defendants to prove the merchants have mitigated their loss. But it notes in the final sentence of 211 that in the context of these appeals, the significance of the legal burden should not be overstated. And it contrasts the case before it with other cases in which the legal burden might be more significant. So 212 is dealing with mitigation where additional benefits have resulted from mitigating action. And 214 is dealing with a failure of a claimant to act reasonably in its response to the loss. So there's the different categories of case which are being distinguished. And over the page on 215, Supreme Court notes we're not concerned in these appeals with additional benefits or an allegation of a failure to take reasonable commercial steps in response to a loss, the issue of mitigation which arises is whether, in fact, the merchants have avoided all or part of their losses. Now, the Supreme Court notes, after quoting Westinghouse, here also a question of legal or proximate causation arises, as the underlying words show, but it states the question of legal causation is straightforward in the context of a retail business, in which the merchant seeks to recover its costs in its annual and other regulatory budgeting. The relevant question is a factual question. Has the claimant in the course of its business recovered from others the costs of the MSC, including the overcharge contained therein? And 216 addresses a practical operation of the evidential burden. So the court notes the legal burden lies on the operators of the schemes to establish that the merchants have recovered the costs incurred in the MSC, but once the defendants have raised the issue of mitigation in the form of pass-on, there is a heavy evidential burden on merchants to provide evidence as to how they have dealt with the recovery of their costs in their business. So the burden is in respect of a specific type of issue, which is how you dealt with the recovery of your costs in your business. And as we will see in this case, we are dealing with a situation in which the claimants were insolvent and in insolvency for a period of 20 years before the judgment was given. And that naturally had an effect on the nature and quality of the evidence and documents that were available in relation to this issue. Now, the court goes on then, having addressed those matters, to deal with the degree of precision that's required in establishing the extent of pass-on over the overcharge. So it's returning to the issue of, well, how specific do you need to be? A court, in applying a compensatory principle, is charged with avoiding undercompensation and also overcompensation. Justice is not achieved if the claimant receives less or more than its actual loss, but in applying the principle, the court must also have regard to another principle enshrined in the overriding objective. The dispute should be dealt with at proportionate cost. The court and the parties may have to forego precision, even where it is possible, if the cost of achieving that precision is disproportionate and rely on estimates. The common law takes a pragmatic view. Now, this issue is revisited at paragraphs 224 and 225. I might take the court to those at 950. As a regime is based on a compensatory principle and envisages claims by direct and indirect purchases in the chain of supply. It is logical that the power to estimate the effects of passing on applies equally when pass-on is used as a sword by a claimant, that's upstream pass-on, and when it's used as a shield by a defendant, or a defendant is saying, you, claimant, have passed it on to your own customers. And the Court of Appeal in 225 makes observations on the facts of that case. It notes the loss caused by the overcharge was an increased cost which the merchants would in all probability not address as an individual cost, but would take into account along with a multiplicity of other costs when developing their annual budgets. The extent to which the merchant utilised each of the four options can only be a matter of estimation. In accordance with the compensatory principle and the principle of proportionality, the law does not require unreasonable precision in the proof of the amount of the prima facie loss which the merchants have passed on to customers. So you don't have to be able to identify a particular cost going through. The fact that there are other responses to the overcharge does not in and of itself defeat pass-on, provided you are persuaded that there is some pass-on, you're able to estimate using the broad act. And 226 is the conclusion, the final paragraph I wanted to take you to. In conclusion, we do not interpret the Court of Appeals having held that defendants had to prove the exact amount of loss mitigated, but insofar as the Court of Appeals required a greater degree of precision in the quantification passed on from defendants than from a claimant, the Court erred. For these reasons, the appeal succeeds on issue 4. So that, my lord, is Sainsbury's in the Supreme Court. I've got 3 other cases that I need to take you to. If it will be convenient, we can start with those tomorrow morning.
Yes, all right. You're still on course, I take it, to finish by about lunchtime.
I am.
Very good. All right, well, in that case, we will adjourn now until 10:30 tomorrow.
All right, Abel.